I would like to say I'm here on special appearance. No, I think I have some rights here. That I'm a living soul. I am not the straw man of the all caps. Okay.
We'll get to that in a moment.
So I am waiving
the time.
I am not waiving any of my rights.
Ma'am.
What statutes or what law or what are you saying here are the charges? Because this does not match. Sorry, I have cotton mouth so bad.
It's really quite simple. When you have an order to show up for court and you turn in a cut up piece of paper of it to say you're refusing to attend, that this is what happens next. That's pretty simple.
Oh, did that offend you? Excuse me. I probably have more degrees than you do.
This
woman, who identifies as a sovereign citizen, completely lost control in court. It was chaos right from the start. She kept interrupting the judge and wouldn't stop talking, throwing out arguments that don't hold any legal weight, like I don't consent or I'm a free citizen of the land. Unfortunately, that kind of talk doesn't mean anything in a courtroom. The judge, to be honest, seemed a bit too patient in this situation and allowed her to keep going rather than stepping in firmly. I won't give too much away. Watch for yourself and let me know what you think about how the judge handled it. Let's dive in and see how this all unfolded. I really feel for the lawyers in that courtroom.
All right, good morning. We are on the record in the 89th District Court for the County of Sheboygan. We're conducting the physical hearing upstairs in the circuit courtroom. It's being clerked by the 89th District Court staff down in that courtroom. And we're here in the case of In re Beth Bridgman on a contempt matter. It was filed in an underlying criminal case 23-0868 SD. We are providing public access both in the courtroom, in the circuit courtroom, and also online. Counsel, you want to state your appearances, please?
Good morning, Your Honor. Paige Miller on behalf of the people.
Attorney Eric Villanueva appearing as a Raymond attorney on behalf of Beth Bridgman.
Right, good morning,
Also, I will represent myself.
Yes,
okay.
We'll get to that.
I would like to say I'm here on special appearance.
Okay.
No, I think I have some rights here. I don't know.
What does special appearance mean to you?
It means in a common law that I'm a living soul. I am not the straw man of the all caps.
And you'll have an opportunity at a later time. Please just take a seat.
I've never seen those opportunities come back around. Thank you. Okay.
We'll get to that in a moment.
So I am waiving
the time.
I am not waiving any of my rights.
Ma'am.
You could see the frustration on one of their faces. They clearly didn't go through law school to deal with this kind of behavior. This situation was challenging, and you could sense how difficult it was for everyone involved. It's tough when someone refuses to follow the process and creates unnecessary tension in the room. Honestly.
Thank you.
Ms. Fitrin, you're free to stand or sit, whichever you're more comfortable with.
I don't know how I would pull the chair up, so thank you.
Well, then, if you want to sit that, I have no problem. All right, Judge Flisher.
Thank you.
All right, well, Ms. Bridgman, you're here for an arraignment on 2 allegations of contempt. So I have to advise you of what those are. The first was an order to show cause that I signed on December 13th, 2023, which alleges that you are in criminal contempt of court for the unauthorized practice of law and for preventing the defendant, Seth Flores, from meeting with the Michigan Indigent Defense Commission attorney prior to his arraignment. We scheduled that for a show cause hearing on December 20th. You did apparently appear in the courthouse that day and turned in a copy of the show cause cut into strips with the red lettering on it. Says your offer to contract is not accepted, and then you did not appear at that show cause hearing. So therefore I signed a warrant for your arrest for that non-appearance. So that warrant alleges that you are in criminal contempt for failing to appear at that show cause.
So
Failing to appear for order to show cause on Wednesday, December 20th, 2023 at 11 a.m. for preventing defendant Seth Miguel Thomas Flores from meeting with MIDC attorney prior to his arraignment. So those are the two contempt citations pending against you. You have the right to have a hearing on both of those allegations, where your contempt would need to be proven beyond a reasonable doubt. You have the right to present evidence in your own defense and cross-examine and challenge any of the evidence presented against you. You have the right to an attorney. If you qualified and requested, you have the right to an attorney appointed at public expense. The MIDC provides an attorney for your arraignment today, just as a courtesy and as required by a
What is
statute.
MIDC?
Michigan Indigent Defense Commission.
You also, of course, have the right to represent yourself. Do you know? Well, first, do you comprehend the penalties? Oh, I'm sorry, I didn't tell you. So both those contempt citations, if you are found to be in contempt or you admit to being in contempt, you could be punished by up to 93 days in the county jail and/or a fine of $7,500 or both. That's the fine. That's the maximum penalty for both of the contempt citations.
90. I wouldn't be surprised if she ends up firing her lawyer and trying to represent herself. She seems determined to go down that path. At this point, it doesn't even feel like she's focused on the outcome anymore. People like this sometimes seem to invite these situations. What's your prediction? Let's continue watching, trying. To act unaware or dismissive in court has to be one of the...
Ms. Bridgman, do you comprehend the rights that you have that I outlined for you and the maximum penalties I outlined for you?
I think that I would like to wait. I have a call in to the state trooper that your office or the prosecutor's office called to investigate something with me. And I was on the phone with her and told her I had received the show cause. And she said, he can't serve a show cause. I shot over a copy of it. He can't serve a show cause because you're not under bond. This is from the state attorney general's office. I was still on the phone with her. I had filed the paperwork at 9 o'clock. She called me at approximately 10 o'clock. I was still on the phone with her till after 11 o'clock. And she told me that you could not issue a show cause because I was not under bond. Now I understand you have just precluded all of my common law rights by forcing me in the back door into your jurisdiction on this side of the court. And I know that this is not what was on the original document in its entirety. So you have amped up the charges based on the fact that I failed to appear, but I believed she was going to let you know. She was collecting information from me for you.
Playing the worst strategies I've seen. What does she expect to gain? Saying she didn't know better doesn't excuse tearing up court documents or scribbling on them. That's not a defense. It's just being disruptive. I don't mean any disrespect to the judge, but I do wish he would have taken stronger action sooner. It was clear she wasn't there to answer his questions. She was just arguing for the sake of...
Ma'am,
Okay, now,
did you just understand what the judge asked you regarding those two charges?
Did you just understand that I think there's a bigger overriding issue?
But
Thank you.
Hang on.
Thank
I'm
you.
not going to have this.
I'm going to fire him, actually, so thank you very much, because I will represent myself.
Okay. So you're telling me things in defense of the contempt citations, and you'll definitely have an opportunity to present any.
No, because you already,
Hang on, Mr. Villanueva, please stop. I don't want to have this be an argument between
Thank
you
you.
and Ms. Bridgman.
I guess I just like to state that
well, I think we need to back it up.
pleading not guilty to both of those, and that she would like to request a hearing, that she would like to represent herself at that future
Okay.
hearing.
No,
Honor,
but
I
all
just
of my
want to-
rights were strongly impinged upon for even when I never failed to appear.
Okay. We're going to have a hearing where you.
She
can
was
present that.
working, okay,
Okay, you're going to get your
Mr.
hearing.
Villanueva,
No,
I'm
this
directing you to
is-
stop
thank you.
arguing with Ms. Bridgman.
Okay.
I mean, it's a pretty serious thing to have to spend the night in jail, to be brought in handcuffs and everything else. When I was not being belligerent in that regard, she told me that it was not an authorized show cause.
All right. If she told you that, she didn't have the authority to do so. But anyway, that's for the later hearing. So
Well, she was
today's purpose is
investigating.
to-
Okay.
Today's purpose is to advise you of the two contempt citations. So do you comprehend the maximum penalty that those could carry and the rights that you have that I outlined for you?
Now, can I ask what statutes or what law or what are you saying here are the charges? Because this does not match. Sorry, I have cotton mouth so bad. This does not match what the previous document was that you sent to me. And I have a picture of it on my phone, but my phone's not with me. Okay? It does not say.
I've told you the charges. I don't have to answer further questions about that from you. Do you understand the rights that I listed for you and the penalties?
Why have they changed, Judge?
I'm not answering that question.
Can the prosecutor?
No.
What?
I need an answer to my question. Do you understand that? So you said you want to represent yourself, right? You wish to represent yourself and not have an attorney represent you?
Yes,
Okay.
I do.
If you want to do that, I must establish that you know what the penalties are and what your rights are. And I have to establish that you're not going to be disruptive to the court. If you refuse, then I'm going to appoint
I'm not
an attorney
refusing.
for you. Okay, then I would appoint an attorney for you and you'd not be able to represent yourself.
I know. I listened to that with Trevor's case.
All right. So I'm asking you, and you saw what
How can I
Mr. Bridgman?
No offense. Of arguing. Every time the judge tried to speak, she cut him off, as if she was in charge. At that point, it felt like she wasn't defending herself anymore, just wasting everyone's time. Is it just me? Or were you also hoping the judge would step in and put an end to this? I get that some judges are more patient than others, but this really dragged on unnecessarily. It almost felt like...
I first have to make sure you know what the maximum penalties are and what your rights are. Do you not?
Those maximal penalties are based on the charges, and I'm wondering how you arrived at a change in the charges.
I'm not answering that question. You know that you could face up to 93 days in jail and over $7,500 fine. You understand that?
Up to that. Okay, but I don't even understand what the charges are.
Okay. And do you have any questions for me about any of the rights that I listed, that you have to have an attorney and have a hearing and present evidence? Do you have any question about any of those rights?
I have a whole question about the whole context of everything today, Judge Gaffier.
It's really quite simple. When you have an order to show up for court and you turn in a cut up piece of paper of it to say you're refusing to attend, that this is what happens next. That's pretty simple.
Oh, did that offend you?
No, it did not offend me. It was a contempt of court.
It's a
It's not
common law
about
thing.
anybody's personal feelings. It's about the authority of the court to compel appearances, and you did not appear. So I do believe, based upon your answers, that you do understand the maximum penalties that you face and the rights that you have. So, Ms. Bridgman, Mr. Villanueva indicated that you wish to plead not guilty to those charges of contempt. I gather from your comments that you would agree that you're not pleading guilty. That's correct. Okay. All right. So we'll enter a not guilty plea on your behalf to both contempt citations. We'll schedule this for a hearing where the prosecutor will present evidence, and you can present evidence in your defense. If you want to have an officer come testify on your behalf, you can certainly do so.
I would like to request a trial by jury.
There is no right to trial by jury in a contempt matter. So
Oh.
that request would be denied.
Okay, so then there's no chance to understand what you're charging me with prior to this hearing.
I've told you what you charged. I can read it again if you want.
The longer it went, the less serious it became. Then, she started mentioning her degrees and qualifications. But honestly, that didn't help her case. It wasn't clear what she was trying to prove, and it just made the situation more awkward. Meanwhile, her lawyer was doing everything possible to protect her from making things worse. One of her main arguments was that a show cause order didn't apply to her because she wasn't on bond. But that's not how it works.
I don't see where there's a code or a statute or any law that I have actually violated here.
Well, that's not required to be on a contempt citation. I've told you what the allegations are. If you want me to read them to you again, I will.
Okay, and the contempt charges that you're saying have changed from the first time.
No, there are two. One is the contempt for unauthorized practice of law and preventing Mr. Flores from meeting with his MIDC attorney prior to his arraignment. The second one is for failing to appear for the show cause hearing on that contempt.
So I only show one. now.
What is,
Okay.
what one do you have?
And this is preventing. And how did you arrive at this at a later date than to issue a bench warrant?
Mr. Villanueva?
There's two items check marked here.
This is after the fact. So then you added a different charge than the previous one about the same date.
Ma'am, he read two charges. There's two charges marked here.
Excuse me. I probably have more degrees than you do.
Wait. Show cause order comes from the court's authority. If you've been released under court conditions, whether on bond, bail, or any other terms, you're still responsible for following the court's orders. It's pretty straightforward. I'm half expecting her to start tearing up more documents like before at this point. She seems to treat court papers like they're just something to scribble on. And you can tell she's thinking, oh, I'll represent myself, that'll be fun. But this isn't a game. It's serious business.
I'm going to find that,
Please, Judge Gothier.
sure, go ahead.
Thank you. Okay. So the first one was that I was practicing law. That was the first one. That's the show cause that you say I failed to appear for.
No, it was contempt for unauthorized practice of law and preventing defendant Flores from meeting with MIDC attorney prior to his arraignment. That was on the original.
No, I have a picture of the original one. This is why I'm not sure.
Do you have a copy of that show cause in front of you right now or no?
This one.
Would you like to see what she has
But-
here?
I just, so if
Okay,
you don't.
so how do I defend?
Hang on. If you do not have in front of you right now a copy of the first show cause, I'm happy to provide a copy to you.
So how did you arrive at a second show cause?
Because you didn't show up. The second show cause is for failing to show
But I wasn't on bond. So both show causes are not in effect because I'm not on bond.
Okay, so
I genuinely can't tell whether she's pretending not to understand what's happening, or if she truly doesn't. This wasn't even her main hearing. It was just a preliminary appearance so the charges could be explained. No final decision was being made yet. But she acted as if it was already the end of the line. What do you think? Playing along, or is she really confused? Personally, I think it might be a bit of both.
Your Honor, what is the date of the first show cause?
December 20th.
No, the December.
Sorry, that was before the December 20th.
Sorry. You may view this document. This is out of the court file. You may view it and then
So-
send it back.
Judge Gothier, do I have any other recourse to clarify where I was on that day and the information that I was going off of by your own investigator?
You do. You do.
Okay.
That is a hearing date. Today, we're going to schedule a hearing date, and you can present that evidence at that time.
And how will the hearing affect a trial by jury
As I told you, there is no right to trial by jury
for
in
a contempt charge?
So I can
Oh, so
schedule
this is a perfect, nice little tidy package.